Everyone. This is Uttam Singh, and I am going to present on the topic administrative law as a byproduct of intensive form of government. So, before going to the topic, let me first tell what is an intensive style of government. So, basically, intensive style of government refers to a type of governance where the government exercises significant control over the activities of its citizens, and this style of governance is often associated with authoritarian regimes where the government has complete control over all the aspects of the society. And when I say all the aspects, it includes economic, social, political, and every other perspectives. And in an intensive form of government, the government typically uses a range of tactics to maintain control over the population, including censorship, propaganda, surveillance, and other repression of dissent. The government may also employ a large bureaucracy to enforce its policy and regulations, and may use force or coercion to quell any opposition. One of the key characteristics of an intensive style of government is lack of transparency and accountability. The government may operate behind the closed doors with a little or no public oversight and make decisions without consulting from the population. So some of the examples of intensive style of government is North Korea, China, and Russia. In these countries, the government exercise tight control over all the aspects of the society, and political opposition is suppressed through censorship, imprisonment, and other forms of coercion. While an intensive style of government can be effective in achieving certain goals, such as maintaining social stability and promoting economic growth, it often comes at an expense of individuals' freedom and democratic principles. In the long run, such government may prone to corruption, political instability, and social unrest as citizens increasingly dissatisfied with the lack of political and social freedoms. So the main emphasis of this video is how an intensive style of government and its governance influenced the development of administrative law. So administrative law has always been regarded as the byproduct of this kind of government. When I say this kind of government, it simply means the intensive style of government. In other ways, it was only a byproduct that has to happen to be employed to help the government and solve their problems and of the present. As governments has developed into many forms, it was inevitable that people could eventually grow so reliant on them that they would even expect a government to take care of them from birth until death. So, administrative law basically focuses on the authority of administrative authorities, how those powers are used, and remedies available to harm parties when those authorities abuse their authority. So, finding measures to keep administration within boundaries so that the discretionary power does not develop into a arbitrary power is the main goal of an administrative law. The goal of administrative law is to harmonize democratic safeguards and fair play requirements with the efficient operation of government in the area of administrative activity. So, the expanded executive powers, as Lord Denning correctly noted, that properly exercised leads to welfare state, but abused leads to a totalitarian state. So here I would like to bring more emphasis on the term administrative law. So we can say administrative law is a law pertaining to administration or law created by the administration. So the latter, which I will say the law created by administration, further comes into two different varieties. And first, it might be administrative authorities who have been given the authority to create such subordinate legislation by a statute. These authorities could create rules, regulations, orders, plans, bylaws, etc. And the second point is certain administrative entities have the authority to adjudicate legal or factual disputes affecting certain individuals generally. Most of these powers are used in quasi judicial fashion. Such choices apply a law, a rule, or instructions to particular circumstances, and they develop a body of administrative law in the process. Government or a government agency is the administration. When I say government or a government agency is the administration, the union and the state each have a portion of state's authority under the Indian constitution. The executive, legislative branch and the judicial branch are the three main departments that make up both union and states. The executive can employ its administrative powers in one of two ways. The it may exercise the executive power of the union or a state, or it may operate in accordance with a specific statute or other laws to subordinate to it. When I say specific statute or other laws that subordinate to it, is like the executive body can make certain rules, like the rules which are not like not written in not in written form or anything. They can bring up some rules and regulations for some legislation which will be followed in every union or state, which will be followed in the union or every state. So this is what it means, that other laws that are subordinate to it, a specific statute for it. So the rule of law always applies to administrative power. So talking about the rule of law and Indian constitution, the Constitution of India is the highest law. The notion of the rule of law is spelled forth in our Constitution's preamble. It is frequently claimed that because of planning and welfare policies have a significant negative impact on people's freedom and liberties, they basically undermine the rule of law. But by emphasizing fair play, more administrative responsibility, the rule of law plays an important role to get rid of administrative arbitrariness. It places more stress on the concepts of natural justice and the rule of speaking order in the administrative process. In the case of S.G. Jaisinghani versus Union of India and others, the Supreme Court very clearly outlined the fundamentals of the rule of law. So in this case, what exactly Supreme Court stated was the first prerequisite of rule of law upon which our entire constitutional system is based is the lack of arbitrary power. When granted to executive authorities, discretion must be maintained within clearly defined boundaries in a system where the rule of law is in place. So according to Supreme Court, the rule of law dictates that judgments should be decided by using established principles and regulations only. And a judgment made without regard to any principle of or laws is unpredictable and is the exact opposite of one made in line with the rule of law. The Supreme Court reaffirmed that lack of arbitrariness in one of the requirement of the rule of law. In the case Supreme Court Advocates on Record Association versus Union of India. So in this case, it was said that the existence of proper guidelines of or norms of general application within the area of discretionary authorities excludes an arbitrary exercise of discretionary authority. And the rule of law to be realistic, there must be spaces for discretionary authority within the operation of the rule of law, even though it must be reduced to a minimum extent necessary for proper governance. When applied to individuals in accordance with appropriate standards and rules, the use of discretionary authority further narrows the scope of the issue. So let's start with the purpose of administrative law: to prevent the abuse of administrative power, to guarantee its citizens an impartial resolution of their disputes by officials in order to safeguard them from the unwarranted infringement of their rights and interests, to hold those positions of public authority accountable to the general populace. So it is vital to have an administrative law system based on fundamental legal and administrative principles in order to achieve these fundamental goals. So, the following, I'll be talking about three fundamental ideas that serve as a cornerstone of an extensive, sophisticated, and successful system of administrative law. Executive accountabilities, which aims to ensure that those who exercise the executive powers of the state can be called on to explain and justify the way in which they have gone about that task. Administrative justice, which at its core is a philosophy that the rights and interests of individuals should be properly safeguarded in administrative decision making. And the second point I want to tell is uh, effective administration. So, when I say effective administration only comes when the decisions and actions taken by the administration or taken in the administration should adhere to the generally recognized norms such as rationalism, fairness, consistency, and transparency. Let me talk about classification of administrative actions. So, when I say classification of administrative action can be broadly categorized into four different categories: the adoption of rules or quasi legislative measures, the quasi judicial or rule, basically the decision activity, and administrative or rule application action, and ministerial action. So these are basically four different types or categories which an administrative actions are categorized. So talking more in depth about it, so, talking about the adoption of rules or quasi legislative measures, any state's legislature in its primary legislative body. The legislature is given explicit authority to make laws in some written constitutions such as American and Australian constitutions, and as a result giving the administration the authority to make laws is compulsion. When any administrative authority uses the lawmaking authority it granted to it by the legislature, it is referred to as lawmaking activity by the administration. For example, the local government taking a law which is being made by the legislative body and making some certain specific rules how they are gonna implement it in their area, and these quasi legislative actions are frequently referred to as delegated legislation as well. The next point I would like to focus on is rule, decision, or quasi judicial action. Today, administrative agencies with adjudicatory powers make the majority of judgments that have an impact on private individual instead of courts. The explanation that has appeared from here is that the traditional judicial system cannot provide the people with the volume of justice necessary in a welfare state because administrative decision making is also a byproduct of intensive style of government. According to this concept, the following administrative duties have been declared to constitute quasi judicial duties. The following duties, when I say it, means the process of disciplining students, disciplinary actions taken against an employee for improper behavior. The Sea Customs Act of 1878 allows for the confiscation of goods. The licensing authority reluctance to renew a license or permit its cancellation, suspension, or revocation. The next point I would like to explain is rule application action or administrative action. Although the lines between quasi judicial and administrative action have blurred, that does not mean that the lines between the two are completely absent. Even if two people are wearing the same coat, that does not mean that they are same. Although the distinct between quasi judicial and administrative action may no longer have much practical significance, it may nevertheless be important for deciding the level of natural justice that should be applied in a particular circumstance. In the case of AK Kripak versus Union of India, the court said that one must consider the nature of the power granted, the recipients of the power, and the context in which the power is granted in order to establish whether an administrative authority's action is administrative or quasi judicial. So, therefore, administrative action is a residual action that falls outside the legislative and judicial realms. It lacks generality and is solely focused on how to handle a specific circumstance. It is not required to follow procedures like gathering evidence and weighing arguments, etc. It is based on subjective gratification, even when the choice is driven by expediency and policy, even while it might have an impact, it does not determine a right. However, this does not imply that while the authority is using its administrative powers, the norms of natural justice can be fully disregarded. Depending on the facts of each case, a minimal set of natural justice principles must always be followed unless the statute specifies otherwise. No comprehensive list of such actions can be made. However, for the clarity's sake, I have made 2 points, which is referring a dispute to a tribunal for resolution in accordance with the Industrial Disputes Act or a selection committee's duties. Administrative action might be statutory, carrying legal weight, or non statutory, lacking legal weight. The majority of administrative action is statutory since the legislation or the constitution grants a legal power, but in other circumstance it may be non-statutory, such when giving orders to subordinates that lack legal authority but may nevertheless result in disciplinary punishment if they are broken. Consequently, at this point, it becomes a crucial to understand the precise distinction between administrative and quasi judicial acts. Therefore, activities that must be completed to the subjective satisfaction of administrative authority are generally referred to administrative act, while actions that must be completed to the objective satisfaction of administrative authority might be referred as quasi judicial acts. There is no legal requirement for a person responsible for making the administrative judgment to take into account and weigh arguments and submissions or to compile any evidence. They justify the justifications for his actions and steps he takes to educate himself before acting are totally up to him. So it is clearly established that the ancient distinction between a judicial act and an administrative act had withered away, and we have been liberated from a presentient incation of administration action, the Supreme Court stated. And after the differences between administrative action and quasi judicial action, let's talk a little about ministerial action. So, talking about ministerial action, it is further derivation of administrative action. A ministerial action is a decision made by an administrative agency that is only motivated by legal obligation and lacks any discretion or independent thought. Performing a specific task for which there is no other option is a ministerial action. One of such ministerial action might be tax collection in the absence of any notes and in administrative instructions. So after this, one of our main topic to study is separation of powers. So, on first appearance, one could assume that India accepts the theory of separation of powers based on the articles of Indian Constitution. According to the Indian Constitution, the president has executive authority, parliament has legislative authority, judiciary has judicial authority. The Constitution itself lists the duties and authority of the President. There are no further restrictions on legislative power of the Parliament, which may enact any law as long as it complies with the Constitution's requirements. And the executive and legislature are not permitted to interfere with judiciary's independence in its area of practice. The Supreme Court and High Courts have the authority to declare any statute passed by the Parliament or the legislature to be unconstitutional thanks to this judicial review power. And some lawyers believe that the notion of separation of powers has been recognized in the Indian Constitution after taking these considerations into account. It is evident from a comprehensive examination of the constitutional provisions that India does not adhere strictly to the theory of separation of powers like USA. In India, there is not only functional overlap but also personal overlap. If legislative or executives activities contravene any provision of the constitution or law approved by the legislature, in case of legislative acts, the Supreme Court has the authority to annul such laws and those actions. By appointing judges and chief justice, the executive has the power to influence how the judiciary operates. Such instances may be continued, but an exhaustive list would not result. So, talking about India's separation of powers and judicial ruling. So, for state, starting up with the case law of Ram Javaya versus State of Punjab. It was subject of judiciary's first significant ruling regarding the doctrine of separation of powers. The court, in the aforementioned instance, believed that India did not completely adopt the theory of separation of powers. The opinion of Mukherjee J further supports the claim that India does not entirely subscribe to aforementioned theory of separation of powers. He claims that although the Indian constitution does not explicitly embrace the notion of separation of powers, the various roles that the various arms of the government play are sufficiently distinct. It was then determined in the case of Indira Nehru Gandhi versus Raj Narayan. So, in this case, Supreme Court was hearing arguments regarding the election of the Prime Minister that the adjudication of a particular dispute is a judicial function of the parliament even when granted constitutional amending power cannot perform. Therefore, the major argument against the amendment was that it violated the separation of powers principle, because when the constituent body proclaimed that the election of the prime minister would not be null and void, it performed a judicial duty that it wasn't supposed to. After this ruling, the possession of this doctrine in the Indian setting became somewhat more obvious. The third case of Keshwan and Bharti versus Union of India, the Supreme Court here held that the Constitution's fundamental principles applied to the amending power. Therefore, any modification that modifies these fundamental elements will be declared unlawful. Separation of powers is a component of constitutional fundamental design according to Justice Begg. None of the republic's three distinct organs may assume responsibility for the other's duty. Therefore, this furthered the court's assessment of the idea of separation of powers. So, after talking about separation of powers, the next topic under this is principles of natural justice. When we say principles of natural justice, the principles of natural justice, also known as the principles of procedural fairness, are a set of fundamental legal principles that ensures fairness, impartiality in decision making processes. There are two key principles of natural justice: the principle of audi alteram partem, or here the other side. This principle requires that both parties involved in a dispute or legal process must be given a fair and reasonable opportunity to be heard before the decision is made. And the next is the principle of nemo judex in causa sua, or no one should be a judge in his own cause. This principle requires that any person or authority responsible for making a decision must be impartial or unbiased and not have any personal interest or stake in the outcome of the decision. Like, we can say that in a judiciary, if the case is against some of the family member of a particular advocate, the advocate should not like be his own family members or relatives advocate to, well, who is directly or indirectly related to him, so that there would be no bias or anything. So in essence of the principle of natural justice ensure that decision makers act fairly, impartially, and without any bias or prejudice, and that all parties involved in a legal process are given a fair and reasonable opportunity to present their case, have their arguments considered before any decision is made. These principles are considered to be the fundamental rule of law and are essentially in maintaining public confidence in the legal system. In Menaka Gandhi case, the court ruled that natural justice is a great humanizing principle meant to invest legislation with fairness and to achieve justice, and that it has ever the year evolved into a widely ubiquitous rule impacting large areas of administrative action. So, fair play in action is therefore the essence of natural justice, which is why it has gained the most widespread acclaim throughout the democratic world. The right to an administrative bureau is seen as an fundamental condition of fairness and truth in United States of America. So, I would like to conclude this video by giving few insights of administrative law is that the independent existence of administrative law has never been contested. However, if one were to draw two circles representing the two branches of law, they would overlap in a specific location, illustrating their tense relationship, and this location could be referred to as the watershed in administrative law. In India, the entire control mechanism established in the constitution for the control of administrative authority, namely Articles 32, 136, 226, 227, 300, and 311, might be included in this watershed as well. And the instructions given to the state under Part 4 may also be included. It may also cover research on administrative agencies covered by 261, Article 261, 263, 280, 315, 323A, and 324 of the Constitution itself. So, talking about some similarities and between the constitution and administrative law, both are a species of public law, and this, in other words, we can say that both deals with the government and individuals and the relation amongst them and the institution of the government. Both deals with the distribution and the exercise of the governmental powers and functions, where constitutional law ends, the administrative law begins. Both are concerned with imposing boundaries and accountability on those that exercise the government powers. Their application is founded on the constitutional study of the administrative law, involves copious reference of the constitutional law. Both of them are concerned with the human rights issues. Both of them rely on the statutes and case laws for their principles and operations. The principles of both are enforced by the same institutions, is that the courts, law enforced agents, etc. And some basic dissimilarities between both of these administrative and constitutional law are, according to Holland, constitutional law describes various organs at rest, and and administrative law describes various organs at government of the government in motion. And according to Ivo Jennings, constitutional law deals with fundamentals, but administrative law deals with details, and constitutional law is majoritarian, whereas administrative law is anti authoritarian. So, after all of this, even while the connection between constitutional law and administrative law is not particularly strong to be seen with the naked eye, the reality remains concomitant issues are not so obscure that one must use a magnifying glass to peer through the text crevices to find the connection. Thank you.